Hello and welcome to the 57 Minutes of Heaven we call the D1Baseball Podcast. I am your host, Michael Patrick Rooney. Today's episode brought to us by our good friends at Pitch Logic, the system used by players, coaches, scouts, and instructors at all levels of play, from youth leagues to the big leagues. The easy-to-use and affordable technology makes the platform accessible to every player at every level. All the metrics and features used at the highest level. See pitchlogic.com for more information. It is the new year, and we have a very special guest and a very special episode tonight. We're joined by Gabe Feldman, who's the director of Tulane Sports Law Program. And you might be saying to yourself, boy, that's an interesting guest for a college baseball podcast. But such is life in college sports right now. And, I think anyone, and particularly the listeners of our podcast, if you're a college baseball fan, you're a college sports fan, and trying to understand the settlement is very challenging. And I've tried to be a good student there. I've tried to be diligent. My sister is an attorney, but I am in no way would have lasted 36 seconds in law school. And Gabe has got a lot of degrees, a very smart man. He's got an undergrad degree from Duke, if I'm not mistaken, a master's degree from Duke. He went to Duke's law school. And I think the reason I asked Gabe to be on our podcast tonight is because he is a resource that I found as I tried to understand the House settlement better and what's happening in college sports. Gabe's podcast is called Sports Wise. It's a podcast about, basically the intersection of sports and law. And so my two sources of truth for this whole thing have been Gabe's podcast, which is excellent. His guests are phenomenal. And then also, our own Kendall Rogers at D1Baseball is so well connected in the industry. He always has great information. I'm going to give the listeners homework. Go get on Gabe's podcast, and episode 69 was a real turning point for me. This is August 2nd of 2024. Gabe's guest was Jeffrey Kessler, who's the lead plaintiff attorney in this class action suit that is the House settlement. And I was really swimming trying to comprehend all this stuff. And again, just to be clear, Mr. Kessler has he's one side of the story, right? Like his firm stands to earn hundreds and hundreds and hundreds of millions of dollars in legal fees were this settlement to come to pass. But I also think he's really, he sells it. It's great. And it's very easy to understand. It's an awesome, again, that's your immediate homework. If you feel like you're swimming, go listen to that episode 69 of Gabe's podcast. So, Gabe, I have an important podcast question for you as I've given this endless introduction. In the beginning of your podcast, there is a very distinct noise. Is that the sound of a wine bottle being opened? Is that a cork being opened?
That is a cork being opened, but that is straight from the song that I play, which is Feel the Pain by Dinosaur Jr. So that's how the actual song starts. It is not me popping a cork. It is the band using that sound effect. They actually just were in New Orleans touring. I unfortunately missed it, but so that's a song, and I will admit that I am testing the boundaries of fair use for copyright law by borrowing that song. But so far I've not had any complaints. We'll see. I would love it, even if they did challenge me. That would be a whole other podcast episode right there. I could just
consider it a
be a podcast
compliment,
about
right?
the podcast. Yeah,
Yeah.
absolutely.
You'll know you've made it at that point. Hey, let me ask you one more background question, Gabe, and then we'll jump in here. Tell me, like, sports and law, like why did that intersect for you? Like, were you a huge sports fan as a kid, or you played sports, or what's been the attraction for you?
Yes to all of that, and like many people, I quickly realized that I was not good enough to play at the professional level, and I still have this note that I took when I was in 5th grade, and they asked you to say what you wanted to be when you grew up. And I'm from New York, was a lifelong New York Jets fan. So some of your older listeners might remember a running back by the name of Freeman McNeil, who was
Wow.
a top running back in the NFL, at least in my eyes, because he was a Jet. And he would get hurt, it seemed like every other play. And I thought to myself, you know what? It'd be pretty awesome to be paid a lot of money, but not have to play. And that I think really set me off as a 10-year-old to find out more about how the relationship between players and leagues worked. And then as I got older, I just became more and more fascinated about trying to figure out why leagues and the NCAA operates the way it does. And the answer to almost all of it is because of the law. And so it started as I'm a sports fan, turned into I really want to know more about how sports work. And then it turned into a career in first representing various different sports entities and now teaching it for a very long time. So it's been kind of a dream come true because I got to talk about sports much like you and work with sports every day.
That's awesome. Freeman McNeil, heck of a running back. UCLA grad, if I'm not mistaken. Is that where he's from?
I
We
think
may,
that's right.
may have to
Yeah,
Google that.
yeah, I think that's right. Well,
Yeah,
if
I love
Freeman
it.
is listening, yeah, then
Yes,
we'll
that's
make
right.
sure we get that right.
Mr. McNeil, please accept our apology if that's not where you went. Hey, so for the listeners, I've got kind of four parts for this this discussion tonight. So number one is why, which I know is a broad and big question, but I think that I'll get some clarity to that in a second. I want to talk about Deloitte's role in all of this, the clearinghouse. I think there's a lot of smoke around that, and potentially a lot of misunderstanding. I want to talk about opt-in versus opt-out. That is a question I'm getting a lot on the baseball side, where we have, over 300 Division I schools, and many of them are not players in football. And so the opt-out versus opt-in, and then the Title IX ramifications of all this. And I think what you said a second ago, Gabe, is really top of mind for me, is that, sure, in college baseball, we'd love to live in our own bubble and just make the rules that are the best for college baseball. But so much of what's happening has to do with the law more than it has to do with the laws of the land, than it has to do with what we think would be best for college baseball. So I guess that would be the first. And by the way, I'm going to speak for Gabe. We reserve the right to be wrong in any of this. Like, this is so fluid, right? Like, now Gabe won't be wrong about the law, but the interpretations of the law, I think we're still waiting to find out so much stuff, and it's changing by the minute, it seems. So, by no means is this is, I think this will be a great conversation, but by no means is this going to be a textbook. So here's my question why, Gabe, to start is, like, why would the NCAA do this? And the only place my brain goes is, hey, like, this is the only way. And when I say this, the House settlement, to stop the constant lawsuits where the NCAA is just like on this terrible losing streak where they lose every single lawsuit. So is that a fair, simple oversimplification there?
I think it's part of it. So I think of the settlement in two ways. One is for the back damages. So that's for all the alleged harm that the NCAA caused these athletes, really dating back from 2016 all the way up to 2024, by not allowing them to be paid for name, image, and likeness, or restricting their ability to be paid for name, image, and likeness. And so there was, depending on your estimate, and Jeffrey Kessler mentioned this on my podcast, he's mentioned this in lots of other places, they were thinking they might be able to get 5 or 6 billion potentially dollars in damages for, again, the restrictions that were in place in the past. And under antitrust law, you multiply that by 3. So we could have been looking at, more than, if it were 4 or 5 billion, we're looking at 12 to 15 billion dollars in damages for what had already happened. So to pay 2.78 billion, which is what the settlement requires, takes a lot of the risk out of it, and it's still a lot of money, but it's a lot less than they would have had to pay if they lost the case after a trial, plus all the legal fees and the time and the uncertainty. So that's part one. Part two is, at least in theory, yes, they do want to end the endless train of antitrust lawsuits. And we've seen that almost every week there is either a new lawsuit reported, or a new threat to file a lawsuit, or there's other people joining these lawsuits. And the NCAA said, we can't operate college sports if every time we institute a rule or try to enforce a rule, we get sued. And that's one of the things I think people overlook as to why the NCAA and also Major League Baseball, now they have their own antitrust exemption, but NFL, NBA, all of the sports leagues have heightened antitrust risk, because one of the big parts of antitrust looks to see if competitors reach an agreement. So if you have Apple and Microsoft and they reach an agreement, we're really worried because they might decide to fix prices, raise prices higher to consumers, all sorts of things that would harm competition. Well, when Vanderbilt and Georgia reach an agreement on when to play a baseball game and what rules to play and how many scholarships to have and roster spots, that's also an agreement between competitors. And so every time the NCAA makes a rule, in other industries would say this is a bunch of competitors making a rule. And whenever competitors make a rule or reach an agreement, that's going to be potentially subject to attack under antitrust law. So the NCAA said the only way we think we can stop this or reduce this is by reaching the settlement. So at least we'll put away with the all the challenges to NIL. Now it turns out that might not actually be the case, but at least that's the theory, is to settle the past damages and create a stable framework for the course of the life of the settlement, which would be 10 years if it's approved, right? It's still not finally approved, but assuming that all goes forward, that's the goal, is to create some stability in terms of past damages, create some stability in terms of the new system going forward.
And do you think that stability, Gabe, like I've interpreted it as there, it's almost like a sacrificial lamb to Congress to say, like, look at what we're doing, and now we need you to help us with antitrust. Is that a misconnection of wires by me, or is there a little bit of that to it?
No, I think that's absolutely part of it. And if you look, and this is the NCAA has said this themselves multiple times, or more than multiple, many multiple times, that they believe that they need help from Congress to protect them from all these lawsuits.
Hmm.
And in a weird way, you can say the more that they lose, the stronger their argument gets in front of Congress to say, look, every time we get sued, we lose. And by the way, this is not the old NCAA. This is the new NCAA that is allowing athletes to be paid for their NIL, that is going to share revenue with the athletes, that is going to loosen all these restrictions, that has loosened lots of restrictions, and yet we're still getting sued. So I do think that is part of it, and that was part of the settlement, is that the plaintiffs would agree in some way to support some federal legislation. But I do think that is in many ways the NCAA's best end game, because even if they get rid of the antitrust lawsuits, there's still the employment lawsuits. Even if they get rid of the employment lawsuits, there's still potential Title IX lawsuits. Even if they get rid of those lawsuits, there's still states that can change their laws to say that athletes should be able to be paid directly, or there shouldn't be any limits on it. So the NCAA's perspective at this point is we need Congress to step in to stop all of these lawsuits. And look, we are doing our best. It's just we keep losing in court. And so we finally need you, Congress, to step up.
Yep. So one of those recent suits, Gabe, is the Diego Pavia, the Vanderbilt quarterback, very famous, where he's gained more eligibility. And this, I'll ask you my question, then I'll explain why I'm asking this. Like the question is this the final signal that we just have to do collective bargaining here? And I'm oversimplifying, because the reason I say that is if you line up 100 constituents in college baseball, or college sports, I should say, 99 and a half of them would say, heck no, athletes shouldn't have unlimited eligibility, which is kind of the road that this is going down, which basically says, I just think there's so many people that think, hey, 5 years is reasonable while you're in school. And Diego Pavia has taken us down a road, or this case is, where it's like you could play college sports forever and people are making money. So do you see it that way, like that collective bargaining is the only way, or a class action suit like this can be a form of collective bargaining?
Yeah, so it's a great question. I would say two things on that. One is class action suits are not great substitutes for collective bargaining. It may turn out that way because of the unique way it's being settled, although that's being challenged, just saying, wait a minute, you're going way beyond the antitrust settlement. It seems like you're trying to just squeeze in a collective bargaining agreement without a union and without the players actually having a seat at the table and negotiating the terms of the deal. But in terms of whether the Pavia lawsuit is just going to the only solution at that point is a labor negotiation and collective bargaining. I don't think necessarily so, and I say that for two reasons. One is the Pavia case is relatively limited. It's one district court judge ruling on one preliminary injunction that affects junior college athletes and their eligibility. People have said the next step would be, well, if you can sue to say I should get an extra year of eligibility just because I was a JUCO player, then maybe the NCAA can't control eligibility limits at all. I don't think that's necessarily what happens next. It could be, but here's what I think the key point is, and where the NCAA has struggled a bit over the last couple of decades, is their main legal argument in almost every area of law has said it's been we need special protection under the law because we are special, we are different, and in particular we're different than pro sports. And what defines us as different than pro sports is that our athletes are students. That's number one. And two is our athletes are not paid beyond their educational expenses. And they have stuck to that as hard as they possibly could for as long as they possibly could. And that they went way overboard for a very long time.
Hmm.
And the spreads and bagels, maybe the most drastic example of that, where the schools could give the athletes bagels, but they couldn't give them spreads because that was an improper benefit. And just these ridiculous stories that would come out. And people said, "Why are you doing this, NCAA?" And their answer was, "We need to maintain this line between college and pro." And what they've been forced to reckon with now is courts saying, "Well, wait a minute. Are all of these restrictions really necessary to maintain that line? Tell us what you really need." And the NCAA is starting to get there to say, "All right, we can give NIL, right? That's not going to destroy the difference between college and pro. Potentially, we can loosen the transfer restrictions. Potentially, we can loosen the JUCO restrictions." The NCAA has to draw a line somewhere and say, "All right, this is what we can get rid of. That's not going to destroy college sports. But here's what we really need."
Hmm.
And I think, and as you suggested, some rule on eligibility would seem reasonably necessary to distinguish college sports from pro sports. And maybe eventually there won't be. Maybe you will have a 19-year veteran playing, shortstop for Vanderbilt. Um, I think the NCAA has a pretty strong argument that there's some restriction, some time limit needed. But what they've run into trouble with is just saying we need the most restrictive rule possible. And why do we need it? Because we get to say it, right? We're the ones who are defining the sport, and we get to decide what's in the best interest of the athletes. And the JUCO rule, it just didn't make a lot of sense on its face. I think to a lot of people to say, well, why are the junior college athletes treated differently? Why shouldn't they get the additional year of eligibility that non-JUCO athletes are getting? So I think what it's going to take is the NCAA going through their thick rule book again and saying, we can take this out, we can take this out, we can take this out, we need to leave this in, and to be able to really justify why the things they're leaving in are needed.
Yeah, almost like they got to pick the hills that they're going to die on. Is what I feel like I hear you saying.
Yeah, otherwise we're just going to die on all of them because
Yeah,
it's
that's
a
right.
little bit of the boy who cries wolf. We can't survive unless we have this rule, and then the rule goes away and they survive. And so they make that argument, and pro leagues have made this argument too. It's not unique to the NCAA, but it's not been as successful, obviously, the last few years for the NCAA.
Yes. Hey, let's come back to collective bargaining. So I have a good friend, Gabe, that is an officer. He's our most successful friend from our group. He's an officer of a Fortune 250 company. He played college sports. His son played.
Who's the least successful?
Oh, maybe me. I have been when I was coaching, I was referred to this as the gym teacher. Not that gym teachers aren't successful, but I'll wear that. I will definitely wear that. So he had an interesting point. Like he played college sports. He's had this great business career. Dealt with a lot of these types of scenarios at a very high level. Also has had a son go play college sports. And so he asked me this question recently, and I'm framing this around collective bargaining because I feel like my naive view of collective bargaining is that the two groups then come together and agree on something such that you can have defendable rules because both parties were at the table when said decision was made. But here's the question: collective bargaining almost always happens between employer and employee is my view of it. And so
It can only happen between
okay, there you
employees.
go. Even better. So that's the problem, right? These are not employees, and a lot of us, that's the hill we want to die on. Is student athletes can't be employees. And he challenged me. He said, "Please tell me why everyone doesn't want them to be employees." And he said, "Is it emotional? Is it just like it just feels wrong?" And I was like, I raised my hand, right? Like, yes, it feels wrong. And then he said, is there a financial ramification? Like, is it the minimum wage laws coming into play? Is it a long-term liability? Is there some type of legal liability that's scaring everyone off there? But because it does feel like one of the easy paths would be, hey, let's make them employees, collectively bargain and come to an agreement, we're off and running. But everyone is anti-employee. So I wanted to ask you that question because I felt ill-equipped to answer it, Gabe. Like, in your opinion, why is everyone against them being employees?
Yeah, it's a great question. Let me just back up for a second. So collective bargaining, there needs to be a union on one side, management on the other side. Our labor law sets it up so that the employees get to decide if they want to be in a union or not be in a union. And if they are in a union, then the employer has to collectively bargain with the union. There is a pretty good indication that the union may not be, maybe, but may not be the best avenue for the employees when the employers are the one asking for the union, which is what you're hearing a lot now, where athletic directors and some presidents are saying the only way we can get this under control is if we recognize them as employees and then collectively bargain with them. That's not the way it works. The employees get to decide if they want to be in a union and collectively bargain. And what we've seen a lot with pro sports, and Jeffrey Kessler has done this, is when there has been a union in place, and this gets to your earlier point, if there is a union and there's a collective bargaining agreement, antitrust law does not apply. Instead, labor law applies. So the product of their agreement, so salary caps, free agency restrictions, all the stuff you see in pro sports, drafts, all of that might be illegal under antitrust law, but you can't challenge it because it's part of a collective bargaining agreement. In the NBA and the NFL, the unions, when they were having difficulty getting what they wanted at the bargaining table, dissolved their unions. Jeffrey Kessler led this charge twice for NFL players and said, we're no longer a union, we're now suing you under antitrust law. And that gave them more leverage. And that's what got them a better deal when they eventually went back to bargaining. They're in the antitrust world right now with Jeffrey Kessler. And I think a lot of the athletes and a lot of the lawyers, plaintiffs lawyers, like the antitrust world better than the labor world because they have more leverage now. Not only do you get the damages, but you get 3 times the damages. And then the last point on that, and then I'll get to the employee question you asked specifically, the power of a union in a lot of ways comes from the ability to strike, the ability to say we are not going to work for a month, 2 months, 3 months, so we can get better terms and conditions of employment for the next 30, 40, 50 years. That's hard to do when your careers are short, when you are going to be replaced, when injury risk is high, when you have another level you want to get to. Even for pro athletes, it's very difficult to take, for example, an NFL player who has a 4-year career on average, to say, sit out a year so that you can benefit the guys that come after you.
Mm-hmm.
Most union members don't have to make that decision. Now think about asking a college athlete to do that, a 19-year-old. Hey, this is your shot to play in the College World Series. Would you mind sitting out so that we can put leverage on the schools and then get more money for the baseball players that come after you? If there is a union of college athletes, depending on who's in it, it might be a really weak union for no reason other than they don't have a lot of incentive to make the fight or fight the fight that most unions would make, or the fight that most unions would fight because their careers are so short.
Mm-hmm.
And with college sports, by definition, it is. Now, maybe that goes back to the eligibility issue. If you could be a college athlete for 20 years, then maybe the union would be stronger. So that's just one piece on collective bargaining and unions. On the employee side, why don't people want athletes to be employees? I would say that more and more people now do want them to be employees, but for the segment of the population that still is strongly against it, I do think part of it is emotional, visceral, just, no, they're students. This is going to destroy the relationship. This is going to destroy the beauty and the purity. And again, destroy what distinguishes college sports from pro sports. But another big part of it, and why the term student athlete was initially created, was to minimize legal liability.
Mm-hmm.
Because if you are an employee and there is an employment relationship, not only is there minimum wage, not only is there potentially collective bargaining, but there's also workers' comp, there's fringe benefits, there's all sorts of legal liabilities and responsibilities that would attach if the student is an employee. There's also the bigger picture risk. If there's an employment relationship between the athlete and the school, does that change the tax status of the schools? Does that mean they're no longer tax exempt because it's not related to an educational purpose, that this is more of a commercial relationship? So there are a lot of challenges to employment status. And I think, last point on this is, I think more and more people are coming around to, well, maybe FBS football players at the highest levels, they look a lot more like employees. But if they're employees, does that mean that every athlete on campus is an employee? And I think that's where athletic directors really get scared to say, wait a minute, we're doing a lot for 99% of our athletes. I mean, for all of them, but for 99% of our athletes, they're getting a great deal through their scholarship, through their access to education, their access to coaching and tutoring and the platform they're given. And if we have to then pay them a minimum wage, it's going to change a lot. And we may have to cut sports. We may have to scale back on sports. It's just the cost of doing business is going to get that much higher. So I think it's a combination of all of those things, and it's just a change to the fundamental relationship. We're used to the athletic director and the coach gets to tell the athlete what they do.
Yep.
And those were the old days in Major League Baseball. The owner got to tell the player exactly what to do and exactly how much they were going to make, and the players had no rights. And that's an easier system if you're management where you get to control every decision.
Is there viability to making the football and basketball players like the revenue generators, employees, and make the rest of the student athletes just student athletes like they've always been, or is that blur the lines too much?
So it's possible, and there's at least two ways to do it. One is, and this is, I asked one of the plaintiff's lawyers, what's the best way for colleges to avoid their athletes being classified as employees? And his answer was stop treating them like employees, and then they won't be employees anymore. So that's one way to do it, is say, all right, football and basketball at certain levels, we're going to treat you differently. We're going to exercise more control over you. We're going to make you travel across the country. You're going to generate a lot of money for us. But for the other sports, in some baseball programs, which some would fall closer to football and basketball, some would fall closer to Olympic sports. But you can say, we're not going to control you as much. We are going to allow you more freedom to act like non-athlete students on campus. A lot of coaches don't want to do that, though. A lot of coaches say we have to continue exercising that control to be competitive. But if you treat them differently, they might be classified differently as one. Or two, this comes back to Congress. You might come in and say, look, we want to provide athletes with more rights, but we don't want it to be a full employment status. So here's what we will promise to give the athletes, but in return, declare that they're not employees. Right? And that's where I think the employee as a sort of the boogeyman. What I ask people when they say the employee classification would be a disaster, I say, well, what part of it would be disastrous? Is it paying them the extra money? Is it giving them their extra insurance? Is it workers' comp? Because you can say, all right, let's give them the things that we believe that they should get, but let's try to not give them the things that will destroy college sports, right? And create sort of a new relationship that's not a typical employee-employer.
That makes sense. Gosh, that's interesting. Let me give you a baseball thing that's going on here, Gabe, that I want to tie into this. So the ABCA, this is the College Baseball Coaches Association's convention was last week or 2 weeks ago, first weekend in January. And one of the great fears for baseball is we now have, if the settlement goes through, they will have to declare a 34-man roster on December 1st, and that would come into play this December. And we do have a roster limit currently, but it's 40 the day before your first game. So what's traditional in baseball right now? Coach, you have an unlimited fall roster. You and your school choose. And then after Thanksgiving, the coaches start meeting with players and say, hey, look, you're not going to be part of the 40. You should look for other places to play, and we'll help you out in that endeavor. Well, now it's going to shrink to 34. The big catch, though, is once you leave that Division I school in the fall, you are ineligible to play Division I baseball in the spring. And 20 years ago, when I was coaching, you would have been eligible if your academics were on par, etc. And it was a nightmare. It was a real, if we think tampering's bad now, we haven't seen anything yet. And I also think it's really hard on the kids. It's hard on the kids that have worked hard all fall and then lose their job to somebody just shows up out of nowhere. It's really hard on that kid. I tell the story, Ian Kinsler was a borderline Hall of Fame big league player. We brought him in January, and he had an awful experience, played terrible because it was unfair to him. So again, Ian was clearly a great player, but the circumstance was really tough. And so what the coaches have done, Gabe, is they said, look, if we go from unlimited to 34 on December 1st, that's God knows how many players that are going to get cut and be made ineligible for Division I baseball. It takes one family to sue the NCAA saying, you cut me, and now you're telling me I can't play Division I baseball. And now the mid-year transfers are back in play, and that's the nightmare we don't want. So what they're doing is they want to be a pioneer sport and go to the Autonomy 4 commissioners and say, look, we're going to self-implement a 38-man roster on the first day of school in August, let's call it August. And then that way, because the coaches are scared that 34 players is not enough to get through a fall season, let alone get into a spring. And so we'll have 4 players that will know exactly, everyone knows exactly what they're getting into. It's 38 and we're cut down to 34, assuming we don't get roster relief from injuries. And, they just want to get ahead of it. I think it's a bold move. I think I'm proud of baseball for taking that initiative, because I've been bothered by the unlimited rosters in the fall. I felt like we've been bad stewards of the baseball talent. But what say you, like from a legal perspective, does that feel defensible, or does it feel like a nice gesture but still not defensible?
Well, I think it's defensible. Whether we'll actually win, I mean, I think most of the rules that have been challenged, including the transfer restrictions, there are real justifications for it. They were not made up just to say we want to screw athletes or we want to limit their rights or
Mm-hmm.
we want to do any of that. I think most organizations say we have a business justification, we have a legitimate sports justification for this rule. It's that, is it narrowly tailored? Is it the least restrictive, or is it not more restrictive than necessary to achieve your goals? And I think that's the work you want to be able to show to a court that hears this case, if they do hear a case, is here's what we're trying to achieve. Right? Here's the goal. It's a legitimate goal. There's no question what we're trying to do is legitimate, and here's what we're trying to do to achieve that goal. And the we're only doing what's absolutely necessary. Right? We're not restricting any athlete rights that we don't need to restrict to get to this goal. But some restriction is needed to achieve this goal. And so I just think it's the more you can make it clear that these are necessary. Now, the challenge and why I think so much of this is so difficult is you're not operating in a vacuum.
Mm-hmm.
And a court might look and say, well, why do these other sports have different rules? Why are you guys special? Right? The shape of your ball is different, and you use a bat, but why do you deserve special treatment?
Mm-hmm.
And I think that's why it may be that we're headed towards more a federated model of sports, of college sports, where the governance is sports specific instead of trying to cram everybody into the same set of rules.
Right.
And the same, now, obviously, they have modifications at different roster sizes depending on the sport, but for the most part, and baseball's been one of the differences in terms of the draft rule, in terms of turning
Sure.
pro, all that sort of stuff. But for the most part, we're treating all of these sports the same, and it's difficult to do that when there are different needs. So if you then create a different set of rules for one sport versus another, the athletes that are harmed in that one sport say, well, why can't you do it like this other sport where these athletes have more rights? So for now, I mean, we're not going to get to a federated model anytime soon.
Mm-hmm.
But for now, again, I think the best you can do is clearly lay out the justifications for it, clearly lay out why there's no better way to do this that would harm the athletes less. And then if you lose, well, add it to the stack of arguments you're bringing to Congress, right? And I believe me, I know that's a terrible way to have to operate a sport
Mm-hmm.
and to have national competitions. And this is a brutal position for coaches and athletic directors and athletes to be in, because whatever the rule might be come July 1, 2025, it might be very different the following year. Right. And so I think a lot of people have said, oh, this is it. This is the end of all the change for college sports. I think this is the very beginning. I just think we're not going to be at a period of equilibrium or stability for a little while now, because I just don't think this, going back to the point we made earlier, the antitrust settlement is not a way to govern sports. So there are not a lot of examples where industries came up with this great new set of rules because they lost an antitrust suit or because they settled an antitrust suit. Right?
Mm-hmm.
This all has to be the administrators, the presidents, the coaches, the athletes sitting together and saying, all right, what are the right rules? What are the rules we need? What are the rules we don't need? I don't think we're anywhere close to that right now.
Yep. Oh man, yeah. I was picturing a scene, I can't remember what movie it is, where somebody is purposely injuring themselves just to look hurt for the sake of their their case.
Yeah,
And that's certainly
yeah. There are a
that's not what.
lot of those.
Yes, that's not
Yeah,
what the NCAA is doing, but they
yeah,
are wearing it. Hey, what
yeah.
so let's do this, Gabe. What about the Deloitte's role in this? So we've got revenue sharing. The schools can do $20.5 million per year, and then anything above that, compensation for athletes has to be, in theory, true blue NIL. And Deloitte has been commissioned by the NCAA, and they will evaluate all these deals and say whether it's fair market value or not. And it's any deal over $600, as I understand it. So as I've looked at this with my simplistic eyes, my thought is, how could Deloitte possibly say no, that's not fair market value? However, if I'm the NCA, I'm not as interested in Deloitte saying no. I'm interested in actual factual data. Like right now, NIL is a dark market. Happens in the shadows, and coaches are often talking about how they just feel like they're just being blatantly lied to by the agents of athletes, and there's no way to police it because you're competing with the people that are also getting these fake bids. And so I don't know, like that's my thought, is that maybe Deloitte's the real end game there is transparency, not like nixing deals. But what's your take on that?
Yeah, I think it's probably both. And I think, again, this is the lead plaintiff's lawyer, Jeffrey Kessler, has been working with professional sports leagues and players associations for a long time. And the model that's coming out of this looks a lot like the pro model. And baseball's different because they don't have a cap, but let's think about the cap sports, the NFL. They have a pretty strict salary cap, and that cap is designed to, among other things, try to achieve parity, competitive balance among the teams, so that any team has a chance of winning on any given Sunday, unless you're a Jets fan like me, and then there's not really much chance that they're going to win. But in theory, that's the goal, and it's also to give some sort of cost stability and make sure that the teams can survive financially. And in order to make sure that the cap works, there are restrictions in place that say athletes can't get paid under the table. They can't get paid in ways that would circumvent the cap, because that would undo the whole purpose of having a salary cap. And we know pro athletes can do endorsement deals,
Mm-hmm.
but the leagues, whether it's the NFL, the NBA, NHL, WNBA, they very strictly monitor endorsement deals and payments that are made to make sure that a billionaire owner doesn't say, I know I can only pay you 30 million under the cap, but I've got a lot of businesses, I'll give you another 10 million in endorsement money. The leagues don't allow that, because that would, again, destroy the entire purpose of a cap. I think that's what the NCAA is trying to recreate here, to say the cap is those revenue sharing payments, right? The 20.5 million that will go up to potentially 33 million in 10 years. So you can pay that. But if the athletes are going to get paid anything else, we have to make sure it's not done to circumvent this cap. And so part of that is, to your point, to give them some transparency, to say, look, you have to report these deals, because we have to make sure they're not being used to circumvent our new cap. And then there has to be some ability to say, all right, we don't think that was a legitimate NIL deal. Now, the big way that they're going to do this is by saying, look, if it's a booster or a collective, we're going to give it stricter scrutiny. If it's a third party that has a business that's selling something and they just hire an athlete to promote that, they're not going to look into that if they have no connection or association with the institution. It's only if it's a booster or a collective, because they're trying to say, look, this collectivism gotten out of control. And many of them are not even hiding the fact that the payments they're making to athletes are to get them to come to the school, not to promote some product. In fact, for many of these collectives, the only thing they have is the collective. So they are asking the athlete to promote the collective when the collective's only goal is to pay the athlete. And so it's not a business model that makes any sense unless you just want to pay money to the athletes.
Yeah.
And so the NCAA says, well, we have to do something to crack down on that. So I think most people would agree that if a school or a booster gives $10 million to an athlete for a single autograph, you'd say that's not a legitimate
Yeah.
NIL deal. You're doing that just because you want to give the athlete money. And if they give them $1 per autograph, you'd say, all right, that seems fine. That doesn't seem like, but what about the stuff in the middle? And the only way they can really do this, and the only way they can really, I think, in a way that's defensible, because they will likely get sued if and when they reject a deal, is to say we're using objective benchmarks. We are looking what non-athlete NIL has been worth, how much a coach might get paid, how much a pro athlete might get paid, how much an influencer, an entertainer might get paid. That's very difficult to do because how do you compare the value of the shortstop at TCU to the random influencer who has funny videos on TikTok?
Mm-hmm.
How do you equate those? I don't think there is any way to do that, but I think what they're going to try to do is create just a wide range of reasonableness and say it at least has to pass the straight face test. Now they'll have
Mm-hmm.
an algorithm. They're not. I don't think they're going to have people looking at each deal and saying that's a good one, that's a bad one, that's a good one, that's a bad one. They're going to plug in their numbers. They're going to plug in the city, and they're going to have spit out what number they think is reasonable. If it's flagged as unreasonable, then I think they'll take a closer look. Um, but again, if they reject a deal, then the athlete may not be able to sue because they may have waived that right under the settlement, but the booster hasn't waived that right. And
Mm-hmm.
so the booster could sue and say, how are you able to come in and say, I can't spend my money this way? And I think it's probably only a matter of when, not if. And then it depends on how aggressive these boosters want to be. If they want to come out and say, we're giving you $2 million and we want you to do 5 posts for us, and Deloitte says that's not fair market value, and they come back and say, yeah, it is. This is what I want to pay. That's what
Mm-hmm.
defines the market, is what people are willing to pay. So it's going to be very interesting to see how those determinations are made early on. And I do think that some schools and some boosters and some athletes are trying to set the market right now and say, look, this is how much they got paid last year. And the rules were still on the books for the NCAA that these NIL deals couldn't be recruiting inducements, and yet they were allowed. So isn't that the market? Hasn't the market been established over these past 3 years? And I think it's going to be a challenge for Deloitte to say, no, we're going to ignore all of the actual college athlete NIL deals and instead look at the non-college athlete NIL deals. So it's going to be fascinating. But Deloitte, it's Deloitte. They're going to spend a lot of time trying to come up with a system that they think is defensible. And then the question is whether that'll hold up, whether there'll be challenges, or whether we have to shift to a new model. And again, this is a broken record here, but if the NCAA can't use Deloitte to try to limit NIL payments, even when the athletes are getting paid a share of that $20.5 million, then again you go to Congress and say, Senator Cruz, Senator whoever, what do you want us to do?
Yeah.
We're just trying to put the same limits that pro sports have. We're not trying to gouge the athletes. We're giving them money and we want them to be allowed to do legitimate NIL deals, but these are illegitimate as this neutral third party decided.
Yeah, it's a really fascinating point you make there, Gabe, about the analog to pro sports. Even though it's not apples to apples, it's not apples to bowling balls either. It's like that's really interesting. Hey, let's do opt-in versus opt-out. I'm getting that question a lot, so I'm going to make you the president and athletic director of a school. What would be your decision criteria? Because I think people are kind of they're because then you're not sure, like, does the roster limit apply to me if I opt in versus opt out? What applies to me? What doesn't apply? So I guess it's a two-part question. What would make someone opt in versus opt out, and what are the ramifications of said decision?
Yeah. So first of all, if you are one of the schools that's in one of the Power Five conferences when the lawsuit was filed, so that includes the Pac-12, you don't have a choice. You're in.
You're in.
You are opted in, which means two things. One is you have the ability to offer these new benefits and payments, which is revenue share, and also you can pay athletes directly for their NIL. Right? All of that would count towards the cap. The other one is the elimination of the scholarship limits, but replacing it with roster limits. And so the Power Five, again, original Power Five schools are stuck with that. They don't have a choice. Everybody outside of the Power Five, again, when the lawsuit was filed, they have a choice whether they want to opt into the terms or not opt in. If they opt in, they can give some of that, whether it's the full 20.5 million or some portion of that, to athletes. They can also provide additional scholarships, but they're subject to those roster limits. And the opt in will happen. You as a school opt in if you essentially give anything that wasn't permitted prior to the House settlement, whether that's an additional scholarship over the roster limit, or that's $10 in payment to an athlete. Either of those would trigger it, means you have to opt into the entire settlement. So you're bound by the roster limits, and you have the ability to pay athletes directly For a lot of schools, the opt-in question comes down to whether they have enough money to actually pay anything meaningful. Because if you look at the Power Four schools, they are going to pay, if not the full 20.5 in year one, pretty close to it.
Mm-hmm.
And if you're a smaller resource school that can't come anywhere close to that, maybe you decide to opt out. And the benefit of opting out is you're not subject to the roster limits. And that there's sort of a double-edged sword, or whatever the opposite of a double-edged sword is. Not only do you not have to pay that additional money, but by not having the roster limits, you get to have additional athletes on your teams. And for a lot of schools, particularly outside the Power Four, a lot of schools, athletes can be revenue generators for the school because
Mm-hmm.
they're paying tuition, or at least they're paying partial tuition. And so the schools that are deciding whether to opt in or opt out have to really make two determinations. One, can they afford to pay the athletes, and how much can they pay them? And then two, can they afford to lose the revenue that comes in from those additional roster spots? And I think what we're going to see is my guess, and what we've seen from what schools have announced, is that a lot of schools don't want to be seen as an opt-out school because they just think it hurts their brand. It shows that
Yep.
they're not trying to compete, that they're not willing to commit the resources. So you might see some schools opt in, but not actually pay any money to athletes, just so they get to say we're an opt-in school, right? We are trying to compete, um, and but not necessarily pay anything more, still be subject to those roster limits. Versus other schools that say no, we are who we are, and we are proudly an opt-out school. Right? We are proudly going to focus on education and also athletic excellence, but we're doing that without paying our players. And then the last piece, and I know this is like, unraveling one little thread, and then all of it pulls apart in lots of different areas. But the schools that do pay their athletes, um, it's going to be harder to argue that those athletes are not employees,
Right.
because what do we call it when somebody performs services you and you pay them for it? Typically that's kind of along the lines of an employment relationship, and that if you control most of their schedule, well, that looks a lot like what we call an employee in every other industry. So it's a little bit of a catch-22. The more rights you give the athletes and the more you pay them, then maybe the more they look like employees, and then even more rights are they entitled to.
Yep. Hey, let's do. Let me. I don't want to lose the thought here. What's your prediction, Gabe? Do you think college athletes are employees in 10 years? We're going to wake up in 10 years and they're employees, or do you think that's not the road we would go down? I'm asking you to take a guess. Clearly.
I think some will be. I think it's more likely than not that some will be, and I think we may see, again, football will drive this train, or football may be the only train, right? That may be what we need to do, is just put the football train on a different track so it's just
Right.
driving itself, and we may see a super league formed with 30 or 40 schools. I think that's what a lot of streaming platforms and TV networks want, is to say we want LSU, Georgia, and something equivalent every Saturday. Right? We don't want this LSU Ball State. No offense to Ball State, but that's not what's getting the viewership. And I think the further we move towards that model, I think the employment model is inevitable there. And then I think it'll look a lot like pro sports. You'll have a union, you'll have collective bargaining, and they'll be able to put some limits on their salaries, because without it, any limitation they try to put on their salaries, they're going to get sued for.
Right. Oh goodness. Hey, so I'm going to give the listeners homework. So I did say our final section would be Title IX, but I don't want to belabor the podcast. This has been awesome. Really, really appreciate your insights, Gabe. You know this subject matter so much better than the average person who really does care about college sports, but this is great. So Title IX, your last podcast on SportsWise, episode 78 in December. I think it was the last one. Who was the attorney that you had that she spoke on this?
Kelly Fagan.
Kelly Fagan. I want to encourage the listeners, go listen to that podcast, because basically Gabe and Kelly went down the road of, okay, what are the Title IX, and I'm simplifying, of course, what are the Title IX ramifications of this? Because I think the layman like myself is saying this to themselves. Okay, if you pay 90% of your revenue share money to football and basketball players, that makes sense because you can show math that says they produce 90% of the revenue. However, you're in tremendous violation of Title IX in theory, So then, okay, you react back. You say, okay, well, I'm going to go 50-50 on revenue sharing, and because of Title IX. Well, then the football, basketball players are going to sue you because they're going to like, hey, we produce 90% of the revenue. We're only getting 50%. So either way, it's another one of these. Cue the video of the NCAA taking another gut punch. But do you have like a big, like a summary judge or like an overview on the Title IX ramifications of this, Gabe?
Yeah, I mean, I think you hit the key point there is that no matter what a school decides to do, there is a decent likelihood they're going to get sued.
Mm-hmm.
And they'll either get sued by the female athletes or they get sued by the male athletes. And the part of the key question here is that Title IX, among other things, applies to athletic opportunities to make sure that there's generally a proportional number of male and female athletes as compared to the student body. It also requires equitable distribution of financial aid. So you have to look at the ratio of male to female athletes, and the financial aid you're distributing has to match up with that ratio of male to female athletes. And then there's what we call the laundry list, where you have to provide equitable access to locker rooms, to training, to equipment, to travel, per diem, food, all that sort of stuff. And the question is whether these new payments, right, that are capped at that $20.5 million, whether they fall under the category of financial aid or as a treatment or benefit. Because if they do, then they have to be distributed equitably, right? And that may differ from school to school, but what we know is it can't be 90% to the male athletes and 10% to the female athletes. That wouldn't be equitable under really any definition of it under Title IX. So if it is treated as financial aid, or if it is treated as a treatment or benefit, they're not going to get away with the 90-10. They're going to get sued.
Mm-hmm.
If it's not financial aid, though, and if it's not considered a treatment or benefit, then they can say, look, or even if it is, they can say, look, the only reason we're giving them 90-10 is not only because that's the revenue they're generating, but objectively speaking, if we try to put a dollar amount on their value, their NIL value, whatever value you want to put it as, it's 90% to male athletes, 10% to female athletes, right? That's not the world we necessarily like or want, but it's the world we're in. And here's the thing, and this is why I liked having Kelly on the podcast, and I think other Title IX folks who convey a similar message. If somebody is telling you they know how a lawsuit under Title IX will be decided, I would listen to somebody else,
Right.
because there is so much uncertainty and so much unpredictability. One, because when Title IX was passed 50 plus years ago, I can't promise you a lot of things, but I can promise you that Congress was not thinking about how it would apply to payments made by schools pursuant to an antitrust settlement, um, to account for, that would be a percentage of the school's revenue, or capped at a percentage of the school's revenue. We don't know how the law was intended to apply to this situation. That's one. Two is the law might change, or at least the interpretation of the law might change. With a Republican administration coming in, and a Republican Senate and a Republican House, there is likely going to be at least changes to the regulations around Title IX,
Mm-hmm.
that may or likely would impact how this case gets decided. So it is, of all the murky areas and all the unpredictable areas. I know this is saying a lot because people who've made it this far in the podcast are probably trying to stab their eye out with a fork, given how murky it is. And imagine my law students have to deal with this every day. But this, I think, is probably the murkiest.
Yeah.
I think this is probably the least predictable, and the only thing that is predictable is that there will be more lawsuits, and that the Title IX plaintiffs' lawyers are already lining it up, just waiting for the light switch to go on in the settlement and a school to start distributing payments or announce it, and there will be a lawsuit.
Yeah. Very fair. All right, two more quick hitters, and then
Yep.
we'll stop. So in early April, again, I'm asking for your gut feel guess here. I'm going to mess up the verb, but will Judge Wilkin ratify this House settlement? What is the verb? I could
Approve.
get
Approve.
approved.
It's the easy word. It's the
There you
easy
go.
word. Yeah.
Gosh, I
You
overthought it.
you try to go fancy. You try to use your honorary law degree. Yes, I think it is. It would be a very large surprise if Judge Wilkin did not approve the settlement. I'll give you two reasons for it quickly. One is because she preliminarily approved it,
Mm-hmm.
and most, if not all, of the objections that are being made to the settlement have really already been made. The arguments we're hearing now aren't necessarily anything new. So Judge Wilkin has heard them and has rejected them. Two, this might be Judge Wilkin's final judicial act. We don't know this for sure, but there are rumors that she is going to retire. So this might be her very last act as a judge. It is the night of the final of the men's national basketball tournament. There's sort of this, I have envisioned her being lowered down onto the court on
Like
Monday night.
Beyonce.
Yeah, for her to just bang the gavel and say approved. And but I just think this is an opportunity, and judges are human, to make her mark on college sports, and she gets to be the one who made this massive change. Now, a lot of people don't like the settlement from the NCAA perspective, the school perspective, and from the athlete perspective. But it's a monumental change, and it's giving athletes a lot of things they have not gotten in the past. So I do think it will be approved. Now, one big caveat to that is if enough athletes opt out of the settlement, so athletes
Mhm.
have until January 31st to say, I don't want to be in this. Instead, I want to keep suing separately because I think I can get more money in my own lawsuit. If enough of those athletes opt out, then the settlement gets undone. That's in the settlement itself.
Is
We don't
enough
know how
like a
many athletes.
number, Gabe, or is
We,
enough like a feel?
the number, no, it's a number. The number is redacted from the settlement, so we don't know what that
Oh,
number
okay.
is. But if it hits that threshold, then it's like a self-destruct button, and the settlement goes away. Now it could be reworked. There's not really the indication that enough athletes will opt out, but that's a possibility too. But again, I think come April 7th or soon after that, I do think the settlement will be approved.
Gotcha. Final question. So your Tulane Green Wave have won back-to-back American Athletic Conference baseball tournaments under head coach Jay Ullman, who I
Coach
knew
Hugh's
when he
been
was
great. Yeah.
he's the best. I knew him when he was at LA Harbor, back here on the West Coast. So Gabe, any truth to the rumor that you are the secret sauce? You are secretly advising Jay Ullman in these. You guys have cracked the code to winning college baseball conference tournaments.
Um, yes, it's true. Uh,
Oh,
Unfortunately, no. I think, look, we have a great tradition of baseball here at
yes.
Tulane, and Coach Hughes done an incredible job of bringing us back, and it's been awesome to see. And our Tulane athletics, pretty much across the board, are on the rise. I would like to say it's all because of me, but I've been here for the times when they were not on the rise. So, but yeah, I think I came up with some new motivational tactics. A couple new signs, just
Love
really
it.
building up the confidence of the players. Yeah, I will tell you, um, I coach my daughter's rec teams, and if you saw the record of my daughter's teams, you would not be asking if I am the secret sauce because we've gone multiple winless seasons.
Oh, that's
Um,
right. Well,
yeah,
youth sports, as long as the orange slices are fresh, it's all good. It's a, yeah, and we know where the Dairy Queens and the ice cream parlors are. We're in good shape. It's
yeah,
all good.
exactly. They demand more than orange slices these days.
Oh,
It's
that's a good point. So, Gabe, this has been awesome. I really appreciate your time. This is, I'm sure you are. I know I am getting so many questions on this. It's very hard to get your arms around, and I think this has been an awesome discussion as far as like trying to, just pare this down a little bit. And it's awesome. Again, like I want to recommend any of our listeners. Gabe's podcast is must listen, especially the one with Jeffrey Kessler. I think is a great starter kit, and then the most recent one with Kelly Fagan on Title IX. So that is it, Gabe. Really appreciate it.
Thanks, Mike.
Yeah,
Yep.
awesome. And we will
I've got
catch.
another
Oh,
big I've got
go
another
ahead.
big episode. I've got another big episode coming out next week that I think you'll enjoy. And I do want to say back to the point you started with that I don't think people realize it. People want exact science. They want exact answers. Here's my legal question. Give me your legal answer. Give me the answer. And it's a little like baseball.
Yeah,
If I get 3 out of 10 right, then I'm a Hall of Famer. It's very hard, just like it's very hard to hit a baseball. It's very hard to predict how a case is going to be decided or how the law is going to play out.
yeah.
So all that we've talked about, it could change. Right? There is just no certainty. There's no stability. There's no predictability. That's why they need lawyers.
That's right. Hey, who's your next guest? Are you allowed to say?
Um, uh, yeah, it's going to be Sedona Prince, who is she's now on TCU, the basketball player, who is one of the named plaintiffs in the House case. So it's Grand
Okay.
House and Sedona Prince. And then Jim Cavell, who is running athletes.org right now.
Well, and they've become a really big, like, I feel like Jim's on a podcast every day now. Like his organization's become a real factor in this thing, it feels like.
Well, but he's saving the good stuff for my podcast.
Of course.
So
Yes.
it's like basically an exclusive podcast.
Those are just tune-ups.
Yes.
Oh, that's
Exactly.
awesome. I can't wait.
Spring training.
Can't wait for that. So good stuff. Gabe, thank you very much. Hey, for the listeners, tons of great stuff on the website right now. Obviously, we are right in the heart of preseasoning, and we will have our rankings came out. We'll have our rankings podcast coming up within the next couple of days. So that's it. Everyone have a great week, and we'll catch you next time on the D1 Baseball Podcast.